Kiddos, do you swear? You promise?
Gotta put up your right hand and say yes.
Yes. Yes.
All right, good. I'm mostly teasing you. I just wanted to see you do that. Okay, Ms. Savage, take it away.
And Your Honor, I would just like to ask the court to take judicial notice of the clerk's file with all the supporting documents.
I did. You're good.
Okay, perfect. And
Judicial notice is taken.
if I can call Ms. Wagner at this time.
Sure.
Ms. Wagner, you are the adoption specialist handling this case, is that correct?
Yes, ma'am.
And you've been able to work with the foster mother and the children in their placement?
Yes, ma'am.
Okay. Are these children free for adoption today?
Yes, ma'am.
And the biological parents' rights have been previously terminated?
Yes, ma'am.
And the children have been in the petitioner's home for longer than 6 months, is that correct?
Correct.
And there is a HESIG waiver that it's been signed by Ms. Beecham?
Correct.
And that's because she is a maternal aunt, is that correct?
Correct.
And the home studies have been filed as well as background checks?
Yes.
And birth verifications for the children are also on file?
Yes, ma'am.
And Belong has consented to this adoption today, is that correct?
Yes.
Do you believe the children are bonded to Ms. Beecham?
100%.
And are the children's needs met in this home?
Oh, yes.
Do you believe this adoption today to be in the children's best interest?
I do, yes.
And if you can just give the court an explanation as to why you feel this adoption is in their best interest.
I mean, I've only known the family for a couple of months, but just in that couple of months, I've seen them grow. I've seen what Rebecca's done with them. I've read their case file and I've seen where they've come from and where they are now and just how close they are as a family.
Thank you. I'll pass the witness, Your Honor.
All right, Ms. Savage, next witness.
If I can call Ms. Rebecca Beecham.
You may.
Ms. Beecham, you are the petitioner today seeking adoption of Chloe and Zane, is that correct?
Yes, ma'am.
And the children have lived with you for longer than 6 months?
Yes, ma'am.
During that time, do you feel that you've become bonded with the children?
Yes.
And do you believe that you can meet the kids' needs now and in the future?
Yes, I do.
And you promise to love, accept, and support the children as if they were born to you?
Yes.
And you are asking for name change for the kids, is that correct?
Yes, ma'am, I am.
So Chloe,
Yes.
Beth, and for Zane, okay. And then you would be also asking the court to order the issuance of new social security numbers for the children?
Yes.
And do you believe this adoption today to be in Chloe and Zane's best interest?
Yes, I do.
I'll pass the witness, Your Honor.
Have you been able to meet all of the kids' needs regarding therapy and education and all of that kind of stuff?
Yes, ma'am, I have.
Have you learned what resources to reach out to if you need help with those?
Yes, I have.
And you understand that they may have needs in the future that you're not aware of. Are you willing to meet those needs or reach out for help for those needs?
Yes, I am.
Do you love these kids like they're already your children?
Yes.
And so is today just about making it official?
Yes.
No further questions.
Any other witnesses, Ms. Savage?
Yes, Your Honor, if I can call Zane and Chloe.
All right. Zane and Chloe, it's your turn.
You guys are the star of the show today. Are y'all excited to be adopted?
Yes.
Yes. And are you guys excited for your name changes? Are y'all okay with that?
Yes. Yes.
Okay. Do y'all have any special plans for today?
Yes. Yes.
I mean, any candy or cake, anything? Today is the day where I feel like y'all could get sweets and get away with it.
Yes.
Oh, they have a whole party set up here. We have a group of what, like 20 people, cupcakes, cakes, balloons, the whole 9 yards.
And then Mr. Gaxter.
Oh, Mr. All right. I'll pass the witnesses, Your Honor.
Ms. Harris?
Do you guys love Rebecca?
Yes. Yes.
Did she take really good care of you?
Yes.
You think she loves you too?
Yes.
So you want the judge to change your names and let her adopt you, right?
Yes.
That's all I have, Your Honor.
All right. Ms. Savage, anything else?
Just if I can get the Casa Volunteers position on the adoption today, Your Honor.
Ms. Peterson? Oh, I'm sorry. Miss Elise is there.
Miss Elise, you've been the Casa volunteer for Zane and Chloe. Are you in support of this adoption today?
Absolutely.
And you feel this adoption would be in their best interest?
Yes, I do. And CASA does.
All right, I'll pass the witness, Your Honor.
Ms. Harris?
Your Honor, I would ask that you grant this adoption. You grant the name changes that are requested. Rebecca has devoted her entire life to these two children. I cannot think of any luckier children there could be in the world. She has done absolutely everything that's been asked of her. She's gone above and beyond. Zane and Chloe clearly love her just as much as she loves them. And I really, really am just thrilled for this to occur today.
Wonderful. Thank you. And I can attest to Miss Beecham having done a lot, and I've seen it. I've been there for the whole thing. And Miss Beecham, I'm so proud of you. I'm so impressed by you. I think I told you that before, but this whole situation has just really made me happy. And I think you've just done an amazing thing here. So, and I appreciate it, all the help that everybody else has given you along the way, but you did all the work. And I agree with Miss Harris. You two kiddos y'all are very blessed to have Miss Beecham looking out for you. And you have to make me a promise that you're going to save some of that candy for me. You're going to save me some candy? All right. Well, with that being said, the court will find that it has jurisdiction over children of this suit based on prior proceedings. Court finds that the children of this suit are under the continuing exclusive jurisdiction of this court, and that all parties entitled to citation and notice were duly cited and served. Court finds that the children are eligible for adoption and that all the prerequisites to the adoption have been met. Court finds it's in the best interest of the children to change their names as requested. All right, I already know Chloe and Zane are correct because I've seen them for so long. It is my pleasure and privilege to say congratulations. The adoption is granted in all respects. Court finds it's in the best interest. You are now a forever family. So celebrate, yell, say yay.
Congratulations.
Looks like they have something there they want to get out.
Congratulations, everyone.
Congratulations, and I'll see you kids shortly.
Hi.
Y'all enjoy your day. Enjoy your
Protective
celebration.
Services versus Kendra Bain, Thomas Albright, in the 198 Judicial District Court of Bandera County, Texas. Ms. Kyla Green, would you please begin the announcements?
Yes, Your Honor. Good morning. Emily Kyla Green, attorney for the department.
Kara McElhenney, investigator for the department.
Jamie Drosnin Mitchell, investigation supervisor. Carol McKetta, family-based supervisor.
Maureen Yanis, attorney ad litem for the mother, Kendra Bain. She is present by phone. It looks like. Judge, ready?
Charles Weatherby, attorney for the
Can
father.
I get the parents to please both?
Oh, Ms. Bain, will you unmute that iPhone and announce?
It's unmuted.
Kendra Bain.
Okay, thank you.
Charles Weatherby, attorney for the father, Mr. Albright. Mr. Albright, would you announce your name and present?
Yes, sir. I'm here. Thomas Albright.
Carol Collins, attorney ad litem for the baby, Hazel.
Lee Hartwick Smith, parent educator with SJRC.
All right, I don't know.
I'm Ashley Leal, prevention director with SJRC.
Can everybody hear me okay?
Yes, sir.
Yes, Your Honor.
You can put your hands down.
You can put your hands down. All right, we've got a delay. We've got internet issues. So if everybody could just bear with me and bear with each other. Ms. Kyla Green, do the parties have an agreement?
Yes, Your Honor, we do. And if you're ready, I can lay it out for the court.
All right, what are the terms of the agreement?
So the parties are in agreement for this Family Preservation Services case. Belong and the department are requesting for the parents to participate in Texas Family First Parents as Teachers program, beginning with weekly in-home services. Also for the parents to be court ordered to participate in a psychological evaluation, each of them, and to follow all recommendations, and to conduct drug and alcohol assessments and to follow any and all recommendations from those. There's been issues, Your Honor, since the filing of this case with the parents' drug testing, whether it's a transportation issue or a communication issue, but either way, the parties are requesting that the court order for the parents to go to G&G testing at 2 p.m. today for, I think, a hair follicle, a UA and a hair follicle. Additionally, the parties agree to hold a family group conference, ideally by next week, with the caregiver to talk about the concerns and to ensure that the child remains safe and that any and all concerns with the parent's ability to provide a safe environment for the child are discussed. I believe that's it. Also, well, I guess I'll also say the request from the department that the parents remain in communication with the caseworkers on this case, because there's been issues with that as well.
And the safety plan, please.
Did everybody hear Ms. Kyler Green?
Yes.
Okay, my connection is really spotty. I think I got it all. I'm gonna go one at a time. Start with you, Ms. Giannis. Is that your understanding of the agreement?
Yes, Judge, it is.
Ms. Collins?
Yes, as an attorney ad litem, I just need to give a brief report to the court, though.
All right, I'll get that in a minute. Mr. Weatherby, is your understanding of the agreement?
Yes, Your Honor.
I'm gonna ask the parents same questions at the same time, okay? Did both of you hear the agreement in entirety?
Yes, Your Honor.
Your Honor.
Did both of you agree to that voluntarily?
Yes, sir.
Yes, sir.
Did both of you have the opportunity to discuss it with your attorney?
Yes, sir.
Were either of you forced in any way to agree to it?
No, sir.
No, Your Honor.
Were either of you made any promises to get you to agree to it?
No, sir.
No.
Are you asking the court to approve your agreement today?
Yes, sir.
Yes, sir.
You understand what's expected of you?
Yes, Your Honor.
Ms. Collins, what is your report?
Your Honor, prior to the report, I just want to make sure that I think this might go without saying, but also there's been a safety plan that's been put in place since the beginning of this case, and we just want to ensure that that safety plan is also followed.
Okay.
Okay, my report, Your Honor, I visited last week with the baby and the mom and the 81-year-old grandma. I do believe she is protective. I was a little bit concerned. She indicated, I think, a little bit of disbelief about the affidavit, which I told her she should take it seriously. She did come across as understanding that the baby could not be left with the parents alone and that she would protect the baby. So the other concern I had when I visited is that it was 11 o'clock in the morning. The mom was there and the grandma and mom was holding the baby. But dad, I asked where dad was, and he was resting, I was told by the mom, which is a little bit unusual for 11 in the morning. And now I'm hearing that the parents haven't been very communicative with the department in the last week, nor have they gone for several requests for drug testing. So that's why we're having the FGC, to make this very clear to them. This is a 2-month-old baby. She's absolutely precious. We don't want her removed, but there definitely needs to be a better understanding of what they're expected to do and more compliance so that we don't have to remove this baby.
Thank you, Ms. Collins. And I'll echo that for the parents. I want to make sure you understand this case is a step below a full removal of the children from your care. And the reason this case was filed is so that that doesn't have to happen. Okay? So you need to comply with the orders. You need to cooperate with the department. Do what they ask you to do, go for the test they ask you to go for, fly with the safety plan so that they don't decide that they need to go to the next level and remove the child, okay? Was everybody able to hear me?
Yes.
Yes, Your Honor.
I'm sorry, I've just got a terrible connection. It's very, very frustrating on my end, but I think we're getting through it. Okay, I'm gonna adopt and approve the agreement of the parties. Were both the parents served?
They were, Your Honor. Citations were returned, I believe, on May 29th.
Okay, court will find that all parties entitled to citation and notice were duly cited and served. Court will adopt and approve the agreement of the parties and order the court-ordered services cases to proceed as stated on the record by Ms. Kyler Green. Court's going to order the parents to go do the UA and hair follicle tests as stated on the record by Ms. Kyler Green. So that's an order. You can't decide whether or not you want to go. I'm ordering you to go do that. You may be positive, and that's not going to surprise anybody. That's why we're in this case. Don't refuse to go because you don't want to know what the results are. You don't want us to see the results. We're trying to get you services, to get you help so we can deal with this issue, keep your family intact.
Yes, sir.
And I'm going to order the parties to continue to comply with the safety plan that's in place. Next hearing is going to be a compliance hearing, August the 11th, 2023 at 10 a.m. That's
Your Honor,
August 11th.
I'm sorry. I have one other request.
What is that?
Just that they understand that they please be court ordered not to alter their hair, and that means coloring, dyeing, shaving their heads, whatever.
I think you're done. Yes, the part of the order that I didn't state, that it's always a standing order of this court. If I order you to go do a hair follicle test, you're not to alter your hair in any way. You can't color it, you can't dye it, you can't cut it, you can't shave it, you can't bleach it. You can wash it with normal shampoo and brush it like you would normally would. Don't do anything else. And Miss Kyler Green, if you could please make sure, thank you. You could please make sure that the statutory findings from the family code pursuant to one of these cases is included in the order.
Yes, Your Honor.
All right, anything else that we need to address or take up?
Your Honor, I think we talked about a hair test scheduled this afternoon for 2:00, and I just wanted to make sure that the parents were aware of that and planning on going.
And Your Honor, it's been scheduled and confirmed by the department that they are scheduled for that at 2 p.m. at G&G.
And I stated that on the record that the agreement as stated by Ms. Kyler Green, which included that drug test, is the order of the court.
Yep.
Anything further?
No.
No, sir.
No, sir. Thank you.
we'll be back, and I hope to hear good things about your progress. Stay in touch with your attorneys and your caseworker.
Please begin
and
the
if nothing
announcements, and
further,
if the
all
attorneys
parties
would
are
please
excused.
prompt their
Thank you.
clients to announce.
Yes, Shona, good afternoon. Emily Kyla Green, attorney for the department. Ms. Peterman?
Ashley Peterman, Child Protective Investigations.
Jimmy Droza Mitchell, Investigation Supervisor.
Jennifer Harris, attorney for respondent mother. Ms. Bindley, can you unmute and announce your name, please?
Megan Bindley.
Richard Saldivar, attorney for the father. Mr. Ray, will you announce, please?
Looks like he's stuck.
Ms. Bindley, it's making that noise because you're both on. You can do just one person.
Okay.
I removed the other user. You're both just going to be on that device, so you can go ahead and announce, sir.
Where keep it?
Kathleen Savage, attorney ad litem for the children, Your Honor, I'm ready.
Leah Peterson, Hill Country Casa Case Supervisor, guardian ad litem for the children.
All right, Ms. Kyla Green, my understanding is the parties were able to come to an agreement.
Yes, Your Honor. And when you're ready, I can read it to the court.
I am ready.
Okay, so the parties agree for the department to become temporary managing conservator over the children in this case, and for the parents to remain as PMC. The parties have agreed already to the placement of the children there. With placement is on this hearing. They're with Mr. Bendley. The parties agree to hold a family group conference to discuss specific services. I do know that one of the specific services that we're going to request is going to be an OSAR for both parents and for them to partake in a drug test, a UA and a hair follicle to assess the beginning stages of where this case is going to go. Visitation has been agreed for 1 hour a week, supervised. I believe by the department. I do know that the parents are requesting for there also to be weekly phone calls due to the concerns with the ability of the parents to get along with caseworkers in this case. The department is not in agreement with that. And so I guess out of all the things that we agree on, that's the one thing that we're that's still a little bit up in the air that we'll defer to the court on whether or not to allow weekly phone calls with the children in addition to the weekly in-person visits. The family group conference, that's when we'll determine the other services to be determined by agreement by the parties and or therapeutic recommendation by a therapist that the parents engage in. I think that's it.
All right. Ms. Savage, is that your understanding of the agreement?
Yes, Your Honor, it is.
Mr. Saldivar?
Yes, Your Honor, that is my understanding. We are requesting phone calls. The children are young. Judge, the parents want to have that communication between the visits so that the children maintain contact with the parents. It would be supervised, Judge, and we're not asking, they're young, so we're not asking for a lot of time on the phone, just say hi, good night, those kind of things. And the only other concern that I wanted to address was adjudicating my client for the youngest child. They have him as alleged. So I just want to see if the parents are not opposed to that, if we can adjudicate him as the father of that child, which would be Bailey.
All right. Ms. Harris, is that your understanding of the agreement?
It is, Your Honor. We are also asking for the phone calls. The children are with relatives. Additionally, this is an 8 and a 9-year-old that are used to being able to talk to their parents and share things with them whenever they want, and a newborn that should be hearing her mother's voice more than once a week. It's my understanding that my client's visitation went good, that she did not do anything appropriate. So I see no reason why they shouldn't be able to have those phone calls. She has also asked for pictures. She has received one, but we're just asking that the parties agree that those will be sent regularly. This is a newborn. Our plan is reunification. So we want to make sure that she's able to get those memories to be able to provide for her child in the future. Additionally, the 8 and the 9-year-old will be doing a lot of traveling this summer, making some really great memories with her uncle and his family. And we would like those pictures shared as well.
Okay.
Your
Costa?
Honor,
Yes, Your Honor, that's our understanding as well.
Okay. Ms. Skylar Green?
Yes, Your Honor, just to clarify, the concern I think that the department has, number one, is that the ability for placement to supervise those phone calls, I think, puts them in an awkward position. So we're not declining or denying that to happen in the future, but I think there's been a lot of hostility and animosity coming from the parents in this case towards the department, and we'd like to prevent that from happening with placement as well. And so we'd like the dust to settle a little bit. Your Honor, we'd like the dust to settle a little bit before we start having the parents calling up placement to speak to their children.
And Your Honor, as the Line for the Kids, I would agree. Right now, I think to preserve the family relationship, I don't think it would be appropriate to have them supervise. I also think there has been a lot of animosity in the case. There was an incident at the visit yesterday, or 2 days ago. So I would ask that we not order the phone calls just yet. Let's get parents and services, let's get counseling recommendations, and then that's something we can definitely discuss in the future.
And Your Honor, I would just argue that punishing the parents for not liking the department is not appropriate. I haven't heard anything that means that the children would be unsafe. The department can manage a phone call 15 minutes a week so that they can all talk to one another. There's no reason they shouldn't be having that.
All right.
Your Honor,
I'll address it. I've heard what I need to hear. I'll address the phone calls.
Judge, I'm sorry. One other thing I forgot to mention, we're not admitting or conceding any of the allegations in the affidavit.
All right.
And the same matter.
Okay. I'm gonna ask the parents, both of you at the same time. Is this the agreement that both of you discussed with your attorneys?
Yes.
Do you understand the agreement?
Yes. Yes.
Are you asking the court to approve the agreement?
Yes. Yes, we're just asking to be able to talk to our kids and get pictures and.
I understand. I understand. I'm not asking about that specifically yet. I'm asking if the agreement that we've heard.
Yes, sir.
That
Yes,
I've
sir.
heard, the agreement you made. Okay. And were you forced to enter into that agreement or made any
No.
promises to get you to agree to it?
No.
Okay. All right then. Were both parents served?
Yes.
Your Honor, they signed waivers of service on 5/25.
Okay. All right. The court will adopt and approve the agreement of the parties, find that both parents sign waivers of service in this suit or have otherwise entered a general appearance. Court finds that the agreement of the parties is in the best interest of the children. Court makes the necessary findings under the Texas Family Code, Chapter 262. And as part of making the reasonable efforts findings and the danger findings, the court will also include a finding pursuant to Chapter 262.013 that the agreement of the parties is not an admission of any of the allegations in the affidavit. Does any party object to stipulating to the reasonable efforts made by the department as stated in the affidavit?
no objection.
No objection, Your Honor.
Court will take judicial notice of the affidavit as far as reasonable efforts are concerned, and the court will order the parties to, or excuse me, let me back up. The court will name the Department of Family Protective Services as the temporary managing conservator, name the parents as temporary possessory conservators, and the court will order the parties to attend an in-person FGC within 30 days of today's date. I'm going to order the parents to meet with the caseworker, and the caseworker, if you need to bring somebody else along, if there's an issue do it in a public place within 5 days to go over what needs to be done after this hearing. I'm going to order the parties to discuss the issue of the phone calls at the FGC. I want one to occur this next week for sure. And then hopefully you can have your family group conference or at least talk to each other and figure out how to make these phone calls work. Because I do believe with the ages of the children that it's in the best interest of the children to have 1 or 2 weekly phone calls moving forward. But
And Your Honor, those will be supervised by CPS, is that correct? Or belong?
correct. But I want you all to talk about it because there's clearly an issue as to how communication is occurring. And so my concern is not only further problems, but we got to get it figured out because we're all about to be spending up to a year or more together on this case. And if there's communication issues, if the parents are having problems communicating with the department or belong, that's got to stop. Ms. Bendeley and Mr. Kevin, I don't know what's going on exactly. I haven't been there, and that's why I'm not making a specific ruling on that as of today. But you're going to be working with the folks from the department and belong for a long time. And if the communication is not respectful both ways, if there's not a willingness to work together, this is going to be a miserable road for everybody, and it's not going to go well. So I want to make it very clear right now that I want you to have this contact with your children, but you've got to respect the caseworkers, the belong folks, the department folks. They're doing their job. You may not like what their job is, but it's their job. And so everybody's got to get along. All right. We're going to have a status hearing on July 14th, 2023 at 1:30. It's July 14th, 2023 at 1:30. We'll come back that day, find out what's going on with the children and the placements. We'll find out what's going on with the parents and how things are proceeding. I have to admonish the parents. The state of Texas gives parents in CPS cases 12 months to demonstrate that you can provide a safe, stable, violence and drug-free home for your children. You cannot do that within the 12-month period. Your rights to your children are subject to restriction and or termination. Ms. Kyler Green, if you could make sure that the order includes the findings as to whether a reasonable person could find that abuse and neglect has occurred in this case or is likely to occur, and the department made reasonable efforts to return the children, but they were not able to return home due to a danger.
Yes, Your
Judge,
Honor, thank you.
Just
Your
the
Honor-
only issue with adjudicating my client the father for Bailey.
That's the next thing I was going to take up.
Okay.
And I was going to request also that the department be ordered to pay for daycare assistance for the children, specifically Bailey, but for all the children.
Is there any objection to daycare assistance for the children?
No, Your Honor.
No, Judge.
No, Your Honor.
So ordered. And as far as the adjudication, this is for Bailey, correct?
Yes, Your Honor.
All right. Mr. Let me get some other screen. Is it Kevin or Kivit?
Kivit.
Kivit. Well, I was wrong on both accounts. Okay. Well, thank God for strike 3. Mr. Kivit, you believe that you are the father of Bailey Kivit?
Without a doubt, that child belongs to me.
All right. Were you on the birth certificate or did you sign an acknowledgement of paternity?
She was born at home. I'm actually the one that I guess played doctor that day and brought her into this world.
All right. So you have no reason to doubt that you are her biological father.
No, sir. Got no reason.
All right.
That child is mine. We can do the foot, hand, and nose test on that one. She looks just like me.
Miss Bendeley, do you have any reason to doubt that Mr. Kivit is the father of Bailey?
No.
All right. And both of you request that he be adjudicated as the father of Bailey Kivit?
Yes.
You understand, Mr. Kivit, if I adjudicate you right now without the benefit of DNA tests, you're going to be the father and you are going to be responsible for this child with all the rights and duties of a father under the Texas Family Code, even if you find out later that she's not your child because you decided to proceed today without a paternity test. You are the father and you are on the hook.
Yes, sir.
You're asking the court to adjudicate you.
Yes.
All right. Anybody else have any questions for either Mr. Keevitt or Ms. Bendelay?
I may, Your Honor, she filled out an affidavit of indigence. I'm not sure if the department filed that or if you want to take that up today.
I do need to take it up. Do either of you have a job at this point in time, Mr. Keevitt or Ms. Bendelay?
I'm self-employed and right now, I don't have a vehicle. My vehicle was stolen. So, I guess at this point, I'm kind of jobless for the.
Okay. What about you, Ms. Bendelay?
No.
Do either one of you have any assets you can sell or any money saved that you could use to hire an attorney?
No.
Are either of you receiving any type of governmental assistance?
No.
Not at this present moment.
Okay, but your testimony is today that you cannot afford an attorney to represent you in this suit?
Yes, sir.
Okay, then for the purposes of this suit, I will find that both parents are indigent at this time and maintain the appointments of their attorneys.
Thank you, sir.
Thank you.
You're welcome. Ms. Kyler Green, is there anything I failed to address?
No, Your Honor. Thank you.
All right, and we can put that adjudication, I don't know if you want to put it in the same order or put it in a separate order. It doesn't matter to me, whatever y'all decide.
Yes, Your Honor. Thank you.
Okay, well, I appreciate you all working something out, coming together, and coming up with an agreement. Again, I can't stress enough, Ms. Bendelay and Mr. Keevitt, you're certainly entitled to your opinions, but everybody's got to work together or this is going to be much more difficult than it needs to be. And I want you all to work on that in family group conference, okay?
Okay.
Thank you all for your time and your service. That concludes the docket for today and this week. Nothing further. All parties are excused.